the appeal in Morrison Sports Limited and others against Scottish Power.
Dean Faculty.
My Lords, my Lady, good morning. I appear with Mr. Barn for the appellants, Scottish Power, in these three appeals. The learned friends, Mr. Ivy and Mr. Stewart, appear for the respondents who are pursuing each of the claims. This is an appeal against an interlocutor of an extra division of the Inner House of 8th December 2009. Leave to appeal that interlocutor in each of the three actions was granted on 13th January of this year. The interlocutor of 8th December 2009 can be found in the core volume at tab 1. That interlocutor repelled the defender's plea of relevancy insofar as directed at the pursuer's case of breach of statutory duty. The relevant plea to the relevancy can be found in the record of the first action at tab 5 of the core bundle at page 27. It is a general plea to relevancy and specification.
Dean Faculty, the implication of the way that the Inner House dealt with the point there in their interlocutor seems to be that all matters of relevancy relating to Article 6 of consent are disposed of if you lose this appeal. In other words, that if the facts were proved, these would constitute breaches of the articles which are specified. Now, is that accepted by
My Lord,
Scottish Power?
That was not put in issue either at first instance, and there was some difficulty over the interlocutor of the Lord Ordinary because he in fact repelled the plea of relevancy in its entirety and was not put in issue before the Inner House, and I don't seek to put it in issue here, and therefore if the facts are as proved, in other words, if we take them pro veritate, then there would, on the face of it, be a breach of the relevant regulations that are listed.
That.
And I'm not intending to take issue with that.
Thank you.
As my Lord has noted, the statutory case is set out in Article 6 of the condescendence in each record and is founded upon alleged breaches of the electricity supply regulations 1988. I shall move this court to recall the interlocutor of 8th December 2009 to sustain the defender's plea of relevancy so far as directed to the pursuer's statutory case in Article 6 of condescendence, and consequently to dismiss those averments from probation on the ground that they are irrelevant.
Yeah.
Lords, my Lady, these three actions arise out of a fire in premises at 23 Moss Street, Paisley.
I think you can take it, Dean, in fact, that we've read the record, we've read the papers, and we're familiar with what the general facts are and so on.
I was just going to notice that although 12 years may have elapsed, the matter at issue is still regarded as one of materiality so far as the power company is concerned. The issue before the court is clearly one of statutory interpretation, and in particular, whether the legislature intended that a breach of the electrical supply regulations by either a supplier or a consumer should give rise to a cause of action in favour of a person who suffers as a result of the breach of the regulations. In approaching the task of interpretation, I submit that the court should have regard not only to the language of the relevant provision, but also to its purpose and indeed its context. To understand the legal framework put in place for electricity, it may help to outline the characteristics of electricity production and supply, and I would seek to do so very briefly. The production or generation of electricity has historically been carried out at a relatively small number of large power stations, although in recent years that has changed somewhat. These generators are connected to a transmission system, which is a network of high voltage conductors known as the grid. And there has been an integrated grid in Great Britain since about 1938, with interconnections between England and Scotland. The grid transmits the generator's output in bulk, in other words, at high voltages, to bulk supply points, otherwise referred to as substations. Voltage is then reduced, and distributors will make electricity available to consumers from the substation, either themselves or once it is taken to the consumer's premises through suppliers. The regulation of electrical generation, transmission and distribution began in 1882, and much of the regulation was incorporated in an Electric Lighting Clauses Act of 1899, and in particular the schedule to that act, which was only repealed in 1989. And the statutory format was one familiar to the courts. It reflected the sort of Land Clauses Act that was employed in regard to railways and the sort of provision that was employed in respect of sewers. And indeed, much of the early legislation was taken directly from legislation with respect to gas, which resulted in some of the early electric legislation referring to high and low pressures and indeed leakages of electricity. The nationalisation of electricity in 1947 led to the integration of 625 companies into 12 boards, with 2 boards in Scotland. Nationalisation also involved the vertical integration of generation, transmission, and distribution. That process was reversed when the privatisation of the electricity industry took place consequent upon the Electricity Act 1989, with further developments by virtue of the Utilities Act in 2000.
You accept that it's the 1989 Act we're concerned with?
I do. Yes. And I acknowledge that that was not the position adopted.
No, but that's now agreed.
Privatisation and consequent competition were achieved by means of a licensing regime that distinguished between generating companies, transmission companies, distribution companies, and supplier companies. The latter, suppliers, are essentially entities which own no hardware. They don't generate, transmit, or distribute electricity, but they compete by virtue of a license in actually supplying to the consumer. So, for example, Marks and Spencer is now a licensed supplier of electricity.
Scottish Power is?
Scottish Power, my lord, and it's the second company in Scotland, although privatised, are to be distinguished from the companies in England insofar as they remain vertically integrated and are therefore licensed to generate, transmit, and distribute electricity. But they do compete with supplier license holders in Scotland. I don't believe it's necessary to go into the background to that, my Lord, but part of it was that Scotland generates a great deal more electricity than it actually consumes. The Utilities Act 2000 passed the principal regulatory functions of the privatised electricity industry from the Director General of Electricity to Ofgem. And the 1989 Act, as amended by the Utilities Act 2000, sets out what is the principal objective of the Secretary of State and Ofgem in this connection.
That's the Act we find at tab 6, is that right?
It is, my Lord. Volume 1, tab 6. Tab 5 is the Act as originally enacted, and it is the one I'll go to in due course,
yes.
for perhaps obvious reasons. But if we go to the Act as amended, it is in Volume 1 at tab 6. And if I can take your Lordships to section 3A, subsections 1 and 2, under the heading, the principal objective and general duties of the Secretary of State and the authority, and it's provided that the principal objective of the Secretary of State and the Gas and Electricity Markets Authority in carrying out their respective functions under this part is to protect the interests of that's existing and future consumers in relation to electricity conveyed by distribution systems or transmission systems, wherever appropriate, by promoting effective competition between persons engaged in or in commercial activities connected with the generation, transmission, distribution or supply of electricity, or the provision or use of electricity interconnectors. And subsection 2, the Secretary of State and the authority shall carry out those functions in the manner which he or it considers is best calculated to further the principal objective, having regard to the need to A, secure that all reasonable demands for electricity are met, B, secure that licence holders are able to finance the activities which are the subject of obligations imposed by or under the relevant acts, and C, the need to contribute to the achievement of sustainable development.
Yes.
We are, of course, immediately concerned with the Electricity Supply Regulations 1988. And your Lordships will find those in Volume 2 at tab 13. I intend to look at them in a little detail in due course, but just for the moment, I would refer to them in order to identify their origins within the statutory framework. If your Lordships turn to the regulations, they will see, just before the introduction, that they are made by the Secretary of State for Energy in relation to England and Wales in exercise of the powers conferred on him by Section 16 of the Energy Act 1983 and Section 64 of the Electricity Act 1947, and the Secretary of State for Scotland in relation to Scotland in exercise of powers conferred on him by the same Section 16 of the 1983 Act and Section 40 of the Electricity Scotland Act 1979. The relevant provision of the 1983 Act can be found at tab 8, which is in Volume 1. For present purposes, my lord, my lady, I don't anticipate that Section 40 of the 1979 Act will have any bearing on matters. If we turn to Section 16 of the 1983 Act, this provided that the Secretary of State may make such regulations as he thinks fit for the purpose of securing that supplies of electricity by electricity boards or other persons are regular and efficient, and B, eliminating or reducing the risks of personal injury or damage to property or interference with its use arising from the supply of electricity by an electricity board or any other person from the use of electricity so supplied, or from the installation, maintenance or use of any electrical plant. And then at subsection 2, without prejudice to the generality of subsection 1 above, regulations under this provision may A, make provision for relieving an electricity board from any obligation to supply or purchase electricity, or to permit the use of the board's transmission and distribution system in cases where electrical plant or fittings or their use do not comply with the regulations. And then there's further provisions with regard to prohibition on the supply of electricity, with regard to compliance with notices. And if we go over to subparagraph F and G, to provide for particular requirements of the regulations to be deemed to be complied with in the case of electrical plant or fittings complying with specific standards or requirements, and to provide for the granting of exemptions from any requirement of the regulations. And then at subsection 3, regulations under this section may provide that any person who contravenes any specified provision of the regulations, or any person who does so in specified circumstances, shall be guilty of an offence under this section. As the court will no doubt be aware, Section 16 of the 1983 Act was repealed by the Electricity Act 1989, and provision was made in Schedule 17 at paragraph 3 of the 1989 Act with regard to the extant regulations, and more particularly the 1988 regulations. And the relevant provision can be found in Volume 1 at tab 5. It's at page 118 of tab 5, taking the pagination written into the top left-hand corner or right-hand corner of each page.
Sorry, where was that?
At tab 5, my lord.
Yes.
Page 118.
I don't seem to have one, but
It's in Volume 1.
I haven't. I've got it, but I don't. I seem
Right
to
at
be,
it's a long way on, right towards the back of the tab.
sorry, what was? I beg your pardon. Sorry, I beg your pardon. Sorry. Yes. No, carry on. No, that's it. Sorry, I've got it. Yes. Yes. Sorry. Yes.
Halfway down the page 118, my lord, Schedule 17,
Yeah.
and at the foot of the page, paragraph 3, any regulations made under Section 16 of the Energy Act 1983, which are effective on the day appointed for the coming into force of Section 29 of this Act, shall have effect as if they were made under the said Section 29. And then there's a provision with regard to references to electricity boards, which arises by virtue of the privatisation implemented by the 1989 Act. And at the top of the next page, and the provisions of Part 1 of this Act shall apply accordingly. And as my Lord and the Chair noted, it is accepted that we have to deal with the provisions of the 1989 Act in construing and applying the 1988 regulations.
Yes.
Now, the position of the respondents is, and has been, that the 1988 regulations were, as a result of the wording of Section 29 of the 1989 Act, which I'll come to, properly construed as conferring a private right of action where none may have existed under the 1983 Act. And we see that reflected in their statement of case and in the inner house note of their case. First of all, if we turn to the respondent's case at page 18, that is in the core volume,
Yes?
paragraph 22.1a, where they're responding to the indicators that were relied on by the extra division of the inner house, they say, it is plain from the terms of section 29, subsection 3, that the Secretary of State is empowered to make regulations under section 29, the breach of the specified provisions of which shall give rise to a criminal penalty. By virtue of the proviso, such regulations also carry a liability to pay compensation for any injury or damage caused by the breach. And this is a proviso introduced into section 29 that was not present in section 16 of the 1983 Act. And the inner house, in their opinion, recorded, and this is in the core bundle, my lords, at tab 2, page 17, paragraph 24.
Yes.
And this is recording the respondent's submissions, referring to the proviso in section 29, subsection 3, and then noting, as in Stevens and General Steam Navigation, the 1988 regulations were, as a result of the chronologically later wording of section 29, subsection 3, properly construed as conferring a private right of action where none may have existed under the 1983 Act.
Yeah. That's really what the inner house held as well, isn't it?
It is. It is. And to put matters shortly, the position of the appellants is that the inner house and indeed the respondents seek to invest too much into the wording which was added to section 29, subsection 3, when it replaced section 16 of the 1983 Act. Query whether there was, of course, a private right of action before the 1989 Act was enacted, a point that I will touch upon in my submissions. But the approach taken by the respondents and indeed by the courts below has been that there has been an innovation in the law by virtue of the proviso added to section 29, subsection 3 of the 1989 Act.
What did the inner house say the position was before that?
They appear, by implication, and I refer back to what they say there, to proceed on the basis that there was no private right of action before the 1989 Act came into force.
Where do they say that?
My Lord, if we go on to paragraph 45 at page 26.
No.
Paragraph 45 is towards the foot of the page.
Yeah.
We accept that a similar reservation provision relating to compensation did not appear in the 1983 Act. That's the proviso. Thus, the wording of section 29, subsection 3 represents an important innovation.
That's got to be read in the light of 44, of course. The very plain meaning is a tended any member of the public suffered aid, blah, blah, blah. Been entitled to raise an action for damages. And you presumably say that's wrong.
Yes, my Lord. I also raise the question of what is a plain meaning? Is it an express provision or is it a necessary implication? It's not at all clear.
It would cover either, wouldn't it?
I think, my Lord, that implicitly is the criticism that I level at it. We don't know what the inner house saw in section 29, subsection 3 that led to this result. Whether they saw it as an express provision or whether they saw it as something from which they could draw an inference.
So what do you say it means then, in fact? That's really the question.
Well, yes, my lord. And it's a point that I intended to approach rapidly, but I wondered if I might just touch very briefly upon the matter of interpretation of such a term. And I was merely going to refer your lordships to certain authorities that are in the appellant's case, but more particularly the observations of Lord Brown Wilkinson in the case of X in Bedfordshire Council, a case that can be found at tab 27. My lords, in doing so, I immediately acknowledge that this is a matter that turns upon the interpretation of the particular statutory provisions before the court, and therefore only guidance can be gleaned from these earlier cases.
There's no real difference between you on the principles, is there?
I don't believe there is, my lord, and that is why I don't intend to go too deeply into this. There is, however, an issue about whether or not the identification of a class is relevant to the process of interpretation. And in regard to that matter, my lord, if Parliament says expressly there will be a private right of action for the public in general, the matter is absolutely clear. But where one is proceeding by inference, one of the guides to that process is whether or not you can identify a relevant class.
Well, could you just say what you say, just so as we know, just not keep us in suspense, dear faculty, and what you say actually the proviso means?
The proviso refers to any potential claim at common law or indeed under statute to other forms of compensation. And in the first place, it is designed to make clear that the introduction of these statutory provisions does not remove any common law right of action that might exist.
Which may exist.
Which may exist. Any liability being the term, not the liability. And I will seek to trace through provisions of this kind in an attempt to explain their apparent utility, although at times the court questioned whether Parliament is perhaps wasting ink when it introduces such provisions, if indeed they are essentially repetitive. But there is some authority to explain why such provisions were introduced into utility acts and regulations of this kind, whether they be electricity, gas, or indeed the provision of other public utilities.
Now you mean by what kind of, I mean, other things like this, right, the proviso to regulation?
The proviso, in very close wording, as we shall see, does emerge much earlier than 1983. My lords, I wish only to touch briefly on the authority that I refer to, but if I can take my lords to Lord Brown Wilkinson, with whom all other members of the court concurred, at page 730 of the report, letter F.
Sorry, I put it away. What volume was it?
It's tab 27 in volume 4, my lord.
Yep. 700 and...
730, my lord.
Thank you.
Paragraph F.
Yep. Yes.
And Lord Brown Wilkinson observed, the question is whether, if Parliament has imposed a statutory duty on an authority to carry out a particular function, a plaintiff who has suffered damage in consequence of the authority's performance or non-performance of that function has a right of action in damages against the authority. It is important to distinguish such actions to recover damages based on a private law cause of action from actions in public law to enforce the due performance of statutory duties now brought by way of judicial review. The breach of a public law right by itself gives rise to no claim for damages, A claim for damages must be based on a private law cause of action. The distinction is important because a number of earlier cases were concerned with the enforcement by declaration and injunction of what would now be called public law duties. They were relied on in argument as authorities supporting the plaintiff's claim for damages in this case. I will consider them in a little more detail later. Private law claims for damages can be classified into 4 different categories. A, actions for breach of statutory duty simpliciter, that is, irrespective of carelessness.
That's what we're talking about here.
Precisely so. And then he goes on to categorise others, which we don't perhaps need to look at in any detail. And then going on to 731C, he observes this category comprises those cases where the statement of claim alleges simply the statutory duty, a breach of that duty causing damage to the plaintiff. The cause of action depends neither on proof of any breach of the plaintiff's common law rights, nor on any allegation of carelessness by the defendant. The principles applicable in determining whether such statutory cause of action exists are now well established, although the application of those principles in any particular case remains difficult. The basic proposition is that in the ordinary case, a breach of statutory duty does not, by itself, give rise to any private law cause of action. And in my respectful submission, that is the proper starting point, and that is the point from which the Inner House should have begun its analysis of the issue. However, a private law cause of action will arise if it can be shown as a matter of construction of the statute that the statutory duty was imposed for the protection of a limited class of the public, and that Parliament intended to confer on members of that class a private right of action for breach of the duty. There is no general rule by reference to which it can be decided whether a statute does create such a right of action, but there are a number of indicators. If the statute provides no other remedy for its breach, and the parliamentary intention to protect a limited class is shown, that indicates that there may be a private right of action, since otherwise there is no method of securing the protection the statute was intended to confer. If the statute does not provide some other means of enforcing the duty...
Some other means.
I'm sorry, my lord.
If the statute does provide some...
If the statute does provide...
Some
sorry,
other
did I misread that?
Yeah.
I apologise. If the statute does provide some other means of enforcing the duty, that will normally indicate that the statutory right was intended to be enforceable by those means and not by private right of action. And that, in my submission, is again a material consideration in the context of the present case. He goes on to note, however, that the mere existence of some other statutory remedy is not necessarily decisive. It is still possible to show that on the true construction of the statute, the protected class was intended by Parliament of a private remedy. Thus, the specific duties imposed on employers in relation to factory premises are enforceable by an action for damages, notwithstanding the imposition by the statutes of criminal penalties for any breach. Although the question is one of statutory construction, and therefore each case turns on the provisions in the relevant statute, it is significant that your lordships will not refer to any case where it had been held that statutory provisions establishing a regulatory system or a scheme of social welfare for the benefit of the public at large have been held to give rise to a private right of action for damages for breach of statutory duty. I may observe that the Inner House sought to distinguish the Electricity Act 1989 and the 1988 regulations on the basis that they fell out with that observation, but in my submission, properly examined, they do not. And his lordship then continued, although regulatory or welfare legislation affecting a particular area of activity does in fact provide protection to those individuals particularly affected by that activity, the legislation is not to be treated as being passed for the benefit of those individuals, but for the benefit of society in general. Thus, legislation regulating the conduct of betting or prisons did not give rise to a statutory right of action vested in those adversely affected by the breach of the statutory provisions. And there's reference there to Cutler's case. The cases where a private right of action for breach of statutory duty have been held to arise are all cases in which the statutory duty has been very limited and specific as opposed to general administrative functions imposed on public bodies and involving the exercise of administrative discretions. Now, again, my lords, I acknowledge that each statute and set of regulations must be examined in the context in which we find them. And these are not hard and fast, immutable rules of construction, but they are guides to construction that the court, in my submission, should properly have regard to when it addresses this issue. And I would note that if we look very generally at electricity and indeed other utilities, there is, in my submission, a theme which can be discerned. For example, where sewers are provided, there is an obligation to allow anyone to connect to those sewers. Where electricity is available, there is an obligation to allow any consumer to be connected to the supply. And similar provisions can be found with regard to other utilities of that kind. Now, again, there is no general and immutable rule that applies to utilities, but in my submission, some notice should be taken of the circumstances in which a party is obliged to allow persons to connect to their sewer, whether they wish it or not, or is obliged to supply electricity, albeit subject to certain qualifications in the regulation.
Here we're concerned with the regulations 17, 24 and 25.
Indeed. And I wonder if before looking at the regulations themselves, my lord, I could look at the Act, which is the source, allegedly, of the parliamentary intention, because this is not, and this should be made clear, because in my respectful submission, there's an element in the inner house judgment that appears to confuse this. This is not a case in which the private right is created by virtue of the regulations and an issue arises as to the vagaries of the regulations. This is a case in which the power is allegedly to be found within the Act itself.
When you say the power, do you mean the right?
The right. It would be a more accurate description, my lord, that the private right of action is to be found within the Act, not within the regulations. There are instances in which, by virtue of the regulations, a minister has purported, or it is alleged that he's purported to confer a private right of action, and the issue that's arisen is whether or not he had the power conferred upon him by Parliament to do that. But that is not this case.
Now, do you say what we're concerned with is we don't need to look at these particular regulations?
Well, we should look at them, my lord, and I will explain why in a moment. But the primary source is the 1989 Act itself. It must be in my submission.
But do you say that, I'm just trying to understand the argument, Dean Fafty. Do you say that section 29.3, which is the one which allows regulations to be made, that either it does or does not permit the making of regulations which allow for a private right of action? Either it does or doesn't. I mean, but you don't need to look at the individual regulations. Is that right?
There is nothing in the regulations themselves that purports to confer a private right of action. And there has been no attempt to construe the regulations themselves as conferring a private right of action. As I understand the position, the argument has always been that the private right of action is conferred by virtue of the proviso in section 29, subsection 3 of the 1989 Act.
But that's not the whole of the argument. Suppose that's wrong, then what?
Then we can look at the 1988 regulations as well, my lord.
But on the respondent's case, if they're wrong on the true construction of section 29.3, then what?
Well, in my submission, then their case fails.
Yes, but is their case that they have an alternative case, do they, on the basis that even if they're wrong about the construction of section 29.3?
I don't understand them to advance an alternative case before this court, that if they're wrong about the construction of section 29, there is in any event a basis for arguing that the statutory regime now found in the 1988 regulations confers a private right of action.
Supposing do you say that if the regulations had said that somebody who suffers personal injury will have a right of action, do you say that that would have been ultra vires?
My Lord, if that issue arose, then there would be an issue as to whether, in fact, Parliament had conferred such a power on the Minister.
What would the answer be?
I would submit that it would be ultra vires,
But then we'd have to construe the rulemaking power.
indeed.
Which is there.
Which takes us back to section 29. My Lord,
Section 29 generally.
I would intend to look both at the Act and then at the regulations, and in particular to look in order to explain where the words in the proviso appear to have come from and why. And in my submission, one can't just go directly to section 29. One must, in my submission, look at it in the context of the 1989 Act as a whole. And I would take your lordships to the 1989 Act as it was enacted, which is at tab 5.
Now, that's the only act we are concerned with, is it?
It is, in my submission.
As enacted? So we're not concerned with the Utilities Act amendments?
For these purposes, my Lord, it respectfully appears to me that if we're to discern the intention of Parliament, we do so by reference to the Act which Parliament passed, namely the original 1989 Act.
Well, it's been amended. I mean, why would the amendments not be relevant?
Well,
Are there any relevant amendments?
there don't appear to be any amendments that are relevant to section 29.
Well, we don't need to get into it. But, I mean, I can't see why, if the section 29 had been amended, one wouldn't construe the whole thing, and it still contains the transitional and so on. I can't see why one wouldn't be, the amendments wouldn't be relevant, but you say there aren't any.
In my submission, there aren't.
But if the amendments had been before the fire?
Yes,
But
exactly.
anyway, if there aren't any, there aren't any.
So we just can, for present purpose, we can look at the unamended version.
In my submission, yes.
Yes.
If your lordships turn to tab 5, we have the 1989 Act as enacted, and at section 3, which I accept has been amended by the Utilities Act 2000, which of course came after
It's after the fire.
after the fire. We have the general duties of the Secretary of State and Director, being the Director General of Electricity at that time, who was succeeded thereafter by Ofgem. And the Secretary of State and the Director shall each have a duty to exercise the functions assigned or transferred to him by this part in the manner which he considers is best calculated. A, to secure all reasonable demands for electricity are satisfied. B, to secure that licence holders are able to finance the carrying on of the activities. And C, to promote competition. And reading short, we go to subsection 3. They shall each have a duty to exercise the functions assigned or transferred in the manner which is considered best calculated to protect the interests of consumers of electricity supplied by persons authorised by licences to supply electricity in respect of prices, continuity of supply and quality. And then again reading short at subparagraph D, to protect the public from dangers arising from the generation, transmission or supply of electricity. And E, to secure the establishment and maintenance of machinery for promoting the health and safety of persons employed in the generation, transmission or supply of electricity. And then if we go over to section 4, there are provisions relating to the licensing of supply and the duty of licence holders with regard to supply. And if we turn on from there to section 16 of the Act, subsection 1, it's headed Duty to Supply on Request. That is at page 15 of the tab. And subject to the following provisions of this part and any regulations made under those provisions, a public electricity supplier shall, upon being required to do so by the owner or occupier of any premises, give a supply of electricity to those premises. And so far as may be necessary for that purpose, provide electric lines or electrical plant or both. So, subject to what follows, there is an overarching statutory obligation to provide a supply of electricity to the owner or occupier of any premises.
Yes.
There is a qualification in section 17, subsection 2, paragraph B. Nothing in section 16.1 above shall be taken as requiring a public electricity supplier to give a supply of electricity to any premises if and to the extent that circumstances exist by reason of which his doing so would or might involve his being in breach of regulations under section 29 below, and he has taken all such steps as it was reasonable to take, both to prevent the circumstances from occurring and to prevent them from having that effect. So there is a qualification on the obligation to supply under reference to any regulations made under section 29. And at section 21, there's a heading, additional terms of supply. And it provides a public electricity supply may require any person who requires a supply of electricity in pursuance of section 16.1 to accept in respect of the supply, A, any restrictions which must be imposed for the purpose of enabling the supplier to comply with the regulations under section 29 below, and B, any terms restricting any liability of the supplier for economic loss resulting from negligence which it is reasonable in all the circumstances for that person to be required to accept. Now, even on the respondent's analysis of the position, as reflected at paragraph 18 of their case, that would mean that a supplier could restrict his liability at common law for economic loss, but could not do so in respect of a private claim for breach of the regulations. And in my submission, one is entitled to ask, what possible utility would that provision have if a breach of the regulations made under section 29 did give rise to a right of action without proof of negligence? I should say that this provision has been the subject of observation by the Court of Appeal, and I wonder if I might take your lordships to that now. It's probably appropriate that I take you to the first instance decision as well, but while we have this particular provision before us, it is the case of Beckett, which can be found in volume 3 at tab 1. The first tab is the decision at first instance, which is a decision of Mr. Peregrine Simon, sitting as a Deputy High Court Judge. And if your lordships go beyond the blue sheet, they will see the report from 2001, One Weekly Law Reports, from the Court of Appeal, which is concerned with section 21. The issue that the Court of Appeal were concerned with turned really upon the provisions with regard to exclusion of economic loss. However, at first instance, the court did purport to make a decision regarding liability in respect of a breach of regulations made under section 29 of the 1989 Act. And if your lordships go to paragraph 25 of the decision at first instance, they will see that the claimant's primary case was that regulation 25, which is one of the regulations relied upon here, gave rise to a distinct civil remedy of strict liability for any breach of the regulations. And reference is then made to Regulation 25 and to Section 29 of the 1989 Act. And continuing at paragraph 29, His Lordship observed, it is clear that Parliament imposed a statutory duty on suppliers of electricity to comply with the regulations. However, the relevant question is whether a claimant who has suffered damage as a consequence of a breach of the regulations has a right of action in damages, irrespective of carelessness. And reference is then made to the dicta of Lord Brown-Wilkinson in X. And passing on from that to the top of the next page, His Lordship observed, while emphasising that each case turns on the provisions of the relevant statute, Lord Brown-Wilkinson identified a number of indicators, and then he refers to those indicators. And then at paragraph 31, he continues, it is arguable that the claimants fell within a class which was intended to be protected by regulations introduced under the powers conferred by section 29(1)(c), namely those affected by the risks of damage to property. However, in my judgment, the claimants fail at the second stage of the analysis, in that it is clear that Parliament did not intend to confer a private right to claim damages for a breach of the statutory duty. First, the sanction of the criminal law for breach of the regulations provides a clear method of securing the protection that the statute was intended to confer and militates against the intention to create private rights of action. Secondly, by section 29, subsection 4, the power to bring criminal proceedings is confined to the Secretary of State and the DPP. This suggests that Parliament did not intend a breach of the regulations to be widely invoked. Thirdly, the claimants rely on the reference to compensation in section 29(3), that is what the respondents refer to as the proviso, as showing that the Act contemplated a civil action for breach of the, and I believe that should be regulations, my lord. However, the reference to compensation in section 29(3) is, in its context, clearly a reference to a claim for compensation under section 35 of the Powers of Criminal Courts Act 1973 and not to a civil action. Well, I would question whether that is the case, my lords.
Why do you question that?
Well, my lords, it appears to me that it may also be a reference to a claim under a civil action.
Well, supposing it were, but why do you say it isn't what
Well, I don't,
Mr. Justice
I'm sorry, my
Simon
lord, I don't say it's exclusively that. I should make clear.
But I mean, from your point of view, is that observation not helpful?
Yes, indeed.
If it were correct.
Indeed, sir.
And do you take the point in relation to the Scottish provision on compensation? Which you'll find in section 249 of the Criminal Procedure Scotland Act of 1995.
The same issue arises, my lord, that there is provision there for compensation.
Yeah.
I accept. I should make clear, my lord, I accept the reasoning here, but I submit that it shouldn't be read so narrowly as to suggest that compensation only refers to the powers to make an award in the context of criminal provision. In my submission, it may extend to compensation arising under a civil action at common law. That is the only point that I make with regard to that part of the dictum, my lord. But I don't question the correctness of the result or the means by which it's arrived at.
But as I understand it, the inner house view is that there's a reference here, in effect, to to some sort of potential liability and damages at common law. And they say that that's what's being. They take. Sorry, there's a breach for liability and damages for breach, a private law action for breach of. Now, if Mr. Justice Simon is right, then that isn't how that particular provision is to be construed. Is that right?
Precisely so.
And that would be good enough from your point of view.
Absolutely. But my lord will be aware that the respondents raise an issue as to whether the reference in this context to compensation could be construed as a reference to compensation under section 247. And I therefore take a broader view of the reference and say that it may embrace not only compensation in that context, but also compensation in the context of a common law claim.
Section 247, do you mean section 249?
249, I apologise.
If the proviso were not there, is there any authority which would help us on the question whether such a provision would be construed to exclude liability for compensation or
yes,
otherwise?
my lord, there is. And I don't know if the Lord wishes me to go to it directly or if I can come to it in a moment.
Take your own course.
It is quite an early authority at first instance, in England. And in the context of the way the regulations have developed, it may explain why this wording has come into, first of all, the regulations and then the Act. Coming back to paragraph 32 of the judgment, we can see that for these reasons, the court rejected the claimant's primary submission. In my view, Mr. Fenwick is correct in his submission that a breach of the regulations may well be prima facie evidence of negligence, but does not give rise to a separate cause of action for breach of statutory duty independent of carelessness. And that is the position of the appellants, of course. Now, the matter did go to the Court of Appeal, and the report from the Court of Appeal is in the second part of tab 1. And the opinion of the Court of Appeal was provided by the then Master of the Rolls, Lord Phillips. You can see that at the second page. However, the crisp issue that we've just looked at was not actually addressed in the Court of Appeal. And turned largely upon the issue of an exclusion clause for economic loss and the construction of that exclusion clause in the context of Section 21 of the 1989 Act. So it's not apparent that the Court of Appeal in any sense disapproved the view taken at first instance, but as a result of submissions that were made in the course of the appeal, the matter went off in the direction of a consideration of the exclusion clause, and the court expressed a view on that in anticipation that the conclusion on that issue was likely to lead to the resolution of the litigation. And that is because, as here, there was a concurrent common law claim as well as a claim under the statute.
It doesn't look as if the claimants appealed.
They didn't cross appeal as far as I can see.
On that point at all.
Milady,
Because that point wouldn't be live, would it?
it doesn't appear to be. But
If there were, no, but if they were right on that there was an absolute duty, they want to get that they had a cause of action for simply breach of the regulation or the statute, the exclusion clause wouldn't be relevant.
Indeed. So it does appear that the Court of Appeal didn't actually address that crisp issue directly. I don't want to spend too long on this case, but if we go, in fact, just to paragraph 38, page 291, the Master of the Rolls observes, these passages do not support the proposition that economic loss in section 21 is restricted to pure economic loss. Whereas Mr. Fenwick demonstrated by reference to subsequent case law, loss of information from a computer as a result of the interruption of supply of electricity may be consequent upon a degree of physical damage. What they demonstrate quite clearly, however, is that Section 21 was introduced to permit exclusion of liability and negligence for economic loss resulting from the interruption or variation of the supply of electricity. And the point really being made there is that the Court of Appeal construed the reference to economic loss as not being limited to pure economic loss, but economic loss arising in the context of an interruption of supply, if that interruption of supply gave rise to physical damage with consequent economic loss. Now, that's rather a long way round, I appreciate, but essentially, I noticed that the Court of Appeal adopted the view, in my submission, the correct view, that what Section 21 of the 1989 Act permits a supplier to do is, by contract, to exclude liability for economic loss resulting from negligence, and that is not just pure economic loss, but consequent economic loss or parasitic economic loss. And I return to my observation that it would be extremely strange if Parliament were to go to the trouble of providing an express statutory mechanism whereby that liability could be excluded for loss resulting from negligence, if in fact there was going to be a liability for such loss arising from a breach of regulations made under the Act without proof of negligence.
Yes?
Going on from section 21, my Lord, and this takes us back to tab 5 in volume 1, to section 22, I simply noticed that supply doesn't necessarily take place only in pursuance of the statutory provisions, because notwithstanding anything in section 16 to 21, a person may enter into a special agreement with the public electricity supplier for the supply on such terms as may be specified in the agreement. And if we go to subsection 3 of section 22, so long as any such agreement as is mentioned is effective, the rights and liabilities of the parties to the agreement should be those arising under the agreement and not those provided for by section 16 to 21 above. There is then at section 23 a provision for the determination of disputes arising with regard to supply. And I don't take your lordship through that in detail, but there are very particular mechanisms employed for the determination of disputes and for the giving of directions with regard to the determination of disputes. And then if we go to section 25, there are orders for securing compliance with the provisions of this part of the Act. And that may involve the making of orders or provisional orders and relevant requirements laid upon the licence holder. A relevant requirement is defined at section 25, subsection 8, in relation to a licence holder to mean any duty or other requirement imposed on him by or under section 9 or section 16 to 23 of the Act. At subsection 3 of section 25, it's provided that in determining for the purposes of this section whether it is requisite that a provisional order be made, the director shall have regard in particular, A, to the extent to which any person is likely to sustain loss or damage in consequence of anything which in contravention of the relevant condition or requirement is likely to be done or omitted to be done before a final order may be made, and B, to the fact that the effect of the provisions in this section and section 27 below is to exclude the availability of any remedy apart from under those provisions or for negligence in respect of any contravention of a relevant condition or requirement. And then section 27 deals with the validity and effect of orders. And in my submission, it's important to note that we're dealing here with orders or provisional orders with regard to an alleged failure to temper regulations with regard to supply. And section 27 provides that if the licence holder to whom a final or provisional order relates is aggrieved by the order, then he may question its validity, and that may be by means of an application to the court. And on such an application, the court may have satisfied that the making or confirmation of the order was not within those powers, or that the interests of the licence holder have been substantially prejudiced by a failure to comply with those requirements, quash the order, or any provision of the order. And then at subsection 3 to 5, except as provided by this section, the validity of a final or provisional order shall not be questioned by any legal proceedings whatever. The obligation to comply with a final or provisional order shall be a duty owed to any person who may be affected by a contravention of the order. Where a duty is owed by virtue of subsection 4 above to any person, any breach of the duty which causes that person to sustain loss or damage shall be actionable at the suit or instance of that person. Now, in my respectful submission, it is noticeable that when it comes to orders or provisional orders, Parliament has been very specific about conferring a right of action where the order or provisional order is not obtempered upon any person who may be affected by the contravention of the order. For by virtue of this section, a duty shall be held owed to that person, and a breach of that duty which causes loss shall be actionable. And in my submission, that's a very long way from the sort of proviso you see in section 29, subsection 3. And it's noticeable that the remedy is not there because of a breach of the regulations or the terms of the license. It is one step away from that. It is a breach of an order requiring a party to obtemper their obligations under the license. So this is not a provision saying the regulations give rise to a civil right of action. This is a very particular right of action in regard to a breach of an order requiring a supplier to obtemper the regulations and terms of his license. Lords, my lady, can I turn on to section 29, with which, of course, we're most immediately concerned, which is at the foot of page 21. The Secretary of State may make such regulations as he thinks fit for the purpose of A, securing that supplies of electricity are regular and efficient, B, protecting the public from dangers arising from the generation, transmission or supply of electricity, from the use of electricity supplied or from the installation, maintenance or use of any electric line or electric plant, and C, without prejudice to the generality of paragraph B above, eliminating or reducing the risks of personal injury or damage to property or interference with its use, arising as mentioned in that paragraph. And then, without prejudice to that generality, the regulations may, A, prohibit the supply or transmission of electricity, B, make provision requiring notice in the prescribed form to be given to the Secretary of State in such cases as may be specified in the regulations of accidents and failures of supply or transmissions. C, make provision for maps and plans. D, make provision for relieving persons authorised by licence to supply electricity from any obligation to supply in such cases as may be prescribed. E, make provision requiring compliance with notices given by the Secretary of State specifying action to be taken in relation to any electric line or electric plant or any electrical appliance under the control of a consumer for the purposes of 1, preventing or ending a breach of regulations under this section, or 2, eliminating or reducing a risk of personal injury or damage to property or interference with its use. I just notice, my lords, my lady, that if the respondents are right in their primary contention, the statutory duty with which we're concerned is imposed not only upon the supplier of electricity, but upon each and every consumer.
What was that point?
I'll develop this a little further when we come to the regulations, but if the respondents are right in their primary contention, then the statutory obligation that they contend for is imposed not only upon the supplier of electricity, but upon each and every consumer. For the Secretary of State may make regulations requiring that the consumer should take action with regard to any electrical appliance, which would include a kettle, under his control, and if there's a failure to do so, there would be a breach of the requisite regulation and consequent civil liability arising out of these statutory provisions. And in my submission, it would be somewhat remarkable to find Parliament imposing such a statutory liability upon consumers by way of a proviso to subsection 3 of section 29 to this Act. If we go on to paragraph F, regulations may provide for particular requirements of the regulations to be deemed to be complied with in the case of any electric line or electrical plant complying with specified standards or requirements. So although the regulations may have a general obligation upon suppliers with regard to electric lines or plant, there may also be room for deeming that lines or plant that don't conform to those regulatory requirements are to be regarded as complying. And then at G, provide for the granting of exemptions from any requirement of the regulations for such periods as may be determined by or under the regulations. So one may find that some parties are simply exempt from the requirements of the regulations for certain periods. And again, in my submission, that is difficult to reconcile with the creation of a civil right of action for breach. Subsection 3, regulations under this section may provide that any person, and any person, of course, includes not only suppliers but consumers, regulations under this section may provide that any person who contravenes any specified provision of the regulations, or who does so in specified circumstances. So it's not a breach of the regulations simpliciter that may give rise to liability. There may be particular circumstances. Shall be liable on summary conviction to a fine not exceeding level 5 on the standard scale, but nothing in this subsection shall affect any liability of any such person to pay compensation in respect of any damage or injury which may have been caused by the contravention. And then there is the limitation on the right of prosecution provided for by subsection 4.
So I understand your point is that there could, at least in theory, be a notice from whoever it is, requiring somebody to not to use a particular kettle or something like that, which had, or a fridge or something which was known to be dangerous or something like that, which might cause. Is that what you're saying?
And then, if it has effect on the supply of electricity over a wider area, that would be breach of an obligation, and we will see that there's provision in the regulations for the consumer to be prosecuted in those circumstances. And the respondents take that as the litmus test for the existence of a civil liability for breach of the regulations. So consumers could be assuming a liability, a strict liability effectively, if they haven't tempered a notice, to an undefined body for an unlimited loss flowing from a breach of the regulations. So this is not just a one-way process. This isn't saying suppliers will have a civil liability. This, according to the respondents, is saying and consumers will have a civil liability for breach of the regulations. Just to touch upon one or two further provisions of the Act before I turn to the regulations. Section 30 makes provision for inspectors to be appointed. And Section 30, subsection 2C, I just noticed the inspectors may inspect and test, if and when required by any consumer, any lines and plant on the consumer's premises, in order to see that any requirement imposed under this part of the Act, and that would include supply and also regulations, has been complied with. So there is a means by which the consumer can seek to check compliance with any of these requirements. At section 39, there's a provision for standards of performance. And these are prescribed by regulation. And subsection 3, if a public electricity supplier fails to meet a prescribed standard, he shall make to any person who is affected by the failure and is of a prescribed description such compensation as may be determined by or under the regulations. The making of compensation under this section in respect of any failure by a public electricity supplier to meet a prescribed standard shall not prejudice any other remedy which may be available in respect of the act or omission which constituted that failure. And the regulatory scheme for compensation is, for an example, a regulation that says if supply is interrupted for more than 30 minutes, you will pay £50 for each 30 minutes thereafter that supply is interrupted. And there are such regulations and have been such regulations in place for some considerable time. But again, there is a structure within the Act for dealing with failure of statutory obligations and indeed for compensating parties with regard to such failure. And there are further provisions with regard to enforcement which can be found at sections 45 and 46 of the Act. Section 45 is at the top of page 31.
So you say that not only consumers would be liable if the respondents are right, but also electrical inspectors under section 30. The duties of an electrical inspector shall such other duties as may be imposed by regulations. Oh, it wouldn't be under that section? No.
It wouldn't be under that section.
Yes, I see, yeah.
Well, section
Yes.
45 is at the top of page 31, subject to subsection...
So do you say section 39 is any direct relevance to this?
It doesn't in my submission. It is itself a self-contained provision that says that there will be certain standards of supply and then makes its own internal regulation and compensatory scheme where there's a failure to obtain.
Well, you say that when, in this Act, Parliament, when it wanted to impose a particular class of duty, cause of action, it does so, or when it wanted to provide for a particular type of compensation, it did so.
Yes, precisely so. Whether it be section 25 or section 39, we can see Parliament expressly addressing an issue of liability and indeed determining how it arises and providing for a system of compensation where required, if necessary. And indeed, that is complemented by sections 45 and 46 in my submission, where there is provision for investigation of enforcement matters by the director.
What is an enforcement matter?
It's defined, my Lord, at subsection 4. In this section and section 46 below, enforcement matter means any matter in respect of which any functions of the director under section 25 above are and may be exercisable.
Okay.
And we looked a moment ago at section 25, my Lord.
Yes, absolutely.
And essentially that's to secure compliance with that part of the Act, my Lord, and in particular conditions in the licence. And then section 46 is there because there were then supply committees or committees, consumer committees, who could then refer relevant matters to the director, and subsection 5 of 46 provides in this section relevant matter in relation to a consumer's committee means any matter other than an enforcement matter in respect to which any functions of the director under this part are or may be exercisable and which relates to a public electricity supplier allocated to the committee or to any other person authorised by licence to supply electricity in that committee's area. So where the committee perceives that there is a failure to temper statutory obligations, they may refer it to the director. And finally, there is at section 60 a power to make regulations. Subsection 1, regulations made under any provision of this part, which of course includes section 29, may provide for the determination of questions of fact or of law which may arise in giving effect to the regulations and for regulating, otherwise in relation to any court proceedings, any matters relating to the practice and procedure to be followed in connection with the determination of such questions, including provision as to the mode of proof of any matter. So again, there is a self-contained scheme, and I accept that there's a proviso in regard to court proceedings, but then there's a provision for criminal prosecution that arises consequent upon the regulations. So in my summation, what we have are all the indices of a self-contained statutory scheme
Yeah.
Could I then refer your lordship to the regulations which are in volume 2 at tab 13?
Yes.
And if your lordships have those at page 3, regulation 2, which is application of the regulations. Subject to the following provisions of this regulation, certain specified regulations shall not apply to suppliers' works or supplies where those works were brought into use or supplies commenced prior to the date of coming into force of these regulations. And Regulation 4 and the proviso to Regulation 25 shall not apply to any supplier's works brought into use on or before 1936. And then paragraph 2, where the regulations specified in paragraph 1 do not apply to any supplier's works or supplies, the provisions of the 1937 regulations or the 1970 regulations, equivalent to the regulations mentioned in paragraph 1, including any approvals or authorities granted or given under those provisions in force in respect of those works or supplies immediately prior to the coming into force of these regulations, shall apply until the date specified in paragraph 3, as if those provisions had been contained in these regulations. In paragraph 3, the date referred to in paragraph 2 is the date on which any material alteration is made to the supplier's works or supplies in question. Now, a number of points may be noted, my lords, my lady. First of all, the 1937 regulations are not revoked. They continue in force and effect. And the reason that they continue in force and effect is because those are the regulations that apply in respect of works completed and carried out before the date of the 1988 regulations, if I can put it very simply. And indeed, a similar scheme pertained when the 1988 regulations were superseded by the 2002 regulations, with which we're not immediately concerned, albeit the 2002 regulations then put down certain specified periods, such as 10 years for compliance with the new regulations. But it would, in my submission, be an unusual situation for us to have a civil right of action arising out of a breach of regulations, the terms of which apply only partially to the supplier's works, and other parts of which are determined and regulated by earlier regulations, if those earlier regulations and the earlier statutory provisions do not give rise to a civil right of action, and the respondents and the inner house are right in saying that the proviso to section 29 subsection 3 is an innovation in the law as at 1989. It's a very strange and, in my respectful submission, confused innovation in the law, if that is what it is. But in my submission, of course, it is not any such thing. As the 1937 regulations remain in force, I would just take your lordship to them for a moment. They are in volume 5 of the appendix at tab 4. And it may help if your lordships also have before them the 1988 regulations at Regulation 39 on page 22 of tab 13. Uh, 39 of the 88 regulations is very short. It says any supplier who fails to comply with any provision of those regulations, any person who fails to comply with Regulation 26, and any consumer who fails to comply with Regulation 38 shall be guilty of an offence under Section 16 of the Energy Act 1983, and that's now Section 29 of the 1989 Act. And that is where we see, for example, that the consumer being liable to prosecution for an offence is also, according to the respondents and the inner house analysis, liable for a civil law claim for a strict breach of the regulations. But if your lordships, my lady, then turn to Regulation 39 of the 1937 regulations, they follow the same format. This is at page 30 of tab 4 in volume 5. It says this: if the undertakers make default in complying with any of the preceding regulations, they shall, subject to the provisions of Regulation 38 and of any act or order relating to the undertaking, be liable on conviction to a penalty not exceeding £10 for every such default, and to a daily penalty not exceeding £10. The recovery of a penalty under these regulations shall not affect the liability, if any, of the undertakers to make compensation in respect of any damage or injury which may have been caused by reason of the default. Now, taking out the word default and substituting the word contravention, you have essentially the same wording in Regulation 39 of the 1937 regulations as has been introduced to Section 29, subsection 3 of the 1989 Act, but which was not present in Section 16 of the 1983 Act and was not present in the 1988 regulations when they were promulgated.
And that would point against Mr. Justice Simon's interpretation.
It would tend to do so indeed, because of, and this is why I was at pains
Yes, no, absolutely, Dean.
to qualify why.
Well, because there was no equivalent provision about compensation in Scots or indeed English law at that time.
Absolutely, absolutely.
Yes, absolutely.
So that is why I'm at pains to say it covers common law
absolutely.
as well
I
as
see it.
criminal. But there's a further point to be made here in my respectful submission. Clearly, if one looks at the 1937 regulations, which are still in force, Section 29.3, and in particular the proviso, is not some innovation in the law in the sense in which it has been construed by the Inner House and the respondents. It's anything but. There is a somewhat peculiar issue here, which is that the 1988 regulations came into force in October 1988, and the 1989 Act, with the proviso in Section 29.3, was not then in force. So there was a period when the proviso wasn't in either the regulations or the Act, or the relevant Act. But that, in my submission, is nothing to the point. What the provision in the 1937 regulations tells us is that this proviso has been around for a very long time. And in my submission, it is worth noticing why it is there. And that brings me back to an observation or an inquiry from Lord Collins about whether there is any guidance as to why Parliament would have wanted to introduce such a proviso into the 1937 regulations.
Is that the first time it appears in 1937?
It does. There is a partial reference. It's not the same wording, but we can take it back, my lord, to 1933 regulations. If I look at a case, Stevens and Aldershot Gas, Water and District Lighting, which is at tab 8 of volume 5. And this is a decision of Mr. Justice McNaughton. And if your lordships turn to page 13 of the report, we see a reference to counsel for the defendants, and it may be appropriate just to note the submissions that were being made from that point, 3/4 of the way down the page. Under Regulations A, and I should explain that what we find now is the 1937 regulations were in fact contained in two separate sets of regulations, A and B, prior to 1937. Under Regulations A, made by the Electricity Commissioners for securing the safety of the public, Section 35 provides that if the undertakers make default in complying with any such regulations, they are liable to a penalty of £10 and a daily penalty of £10, and the recovery of the penalty is not to affect the liability of the undertakers to make compensation for any damage or injury caused by the default.
Find that in note 2, footnote 2.
We do. And then, under the regulations for ensuring a proper and sufficient supply of electrical energy, B, a penalty only is provided for default, and the words as to liability of the undertakers to make compensation are omitted. These regulations are made under the Act and are part of it, and the default here, if any, is in not ensuring a proper and sufficient supply of electrical energy. And then the Plaintiffs' Counsel submit that no authority limits the rights of a person who proves negligence to penalties under the statute. Nonfeasance is different from misfeasance. The statute provides a remedy for nonfeasance only. And if we go on to page 15 in the judgment of Mr. Justice McNaughton, he observes the Electric Lighting Act 1882 by Section 5 and Section 6 provides for the Board of Trade making regulations. Under the regulations dealing with the question of a proper supply, the undertakers are bound to declare the pressure, and if they make default in supplying current at the declared pressure, they are liable to a penalty. There are two sets of regulations, and it is significant that in Regulation B, for ensuring a proper supply, the words, "The recovery of a penalty under these regulations shall not affect the liability of the undertakers to make compensation in respect of any damage or injury," are omitted. These words appear in Regulations A for securing the safety of the public. Where a statutory duty is imposed and where in consequence an individual has suffered loss and a question arises as to whether he can claim damages at common law or must proceed under the statute, the decision must be that his remedy lies under the statute. This is now well established, and so far as this case goes, I am bound to follow the judgment in Clegg, Parkinson and Airbay Gas. There it was decided that an action does not lie for damages sustained by a consumer by reason of a failure to supply gas. I think that although it appears the question has not been raised previously, the consumer of electricity who is receiving a supply by virtue of a statutory right and not by virtue of a special contract has no right to damages at common law in case of default. The plaintiff states that she puts her case not on the footing of a breach of statutory duty, but on negligence in failing to supply a proper voltage. Counsel for the plaintiff has drawn my attention to the case of Milnes and Huddersfield. I am unable, however, to say in this case that there was any negligence other than a failure to comply with the statutory duties to supply current at 100 volts. The defendants put in a transformer and they thought that would be adequate for the purpose. It may be said that they failed to put in an adequate transformer and that this may be negligence. That is only saying again that they have failed to comply with the statutory duty to supply current at 100 volts. It is provided by paragraph 30 of the schedule of the Electric Lighting Clauses Act 1899 that exemption from penalties should be given only where the default was caused by inevitable accident or force majeure. This action is not maintainable, and there must be judgment for the defendants with costs and an order for payment to the defendants of the money paid into court with the defence. My Lords, as I read that judgment, what the court was saying is that in the absence of the words that we now see in the proviso, there is no common law right of action for negligence.
But would there have been a right of... It's somewhat confused, this reasoning, to my mind. With great respect to Mr. Justice McDonald.
Unreserved judgment.
Would there have been a cause of action at common law?
Well,
absent these provisions?
It appears so. That is how I...
What would the cause of action be?
For negligent provision of the transformer.
Well, on the basis of what
that the transformer would not have been capable of providing the necessary voltage as specified under the regulations.
Then how would the common law have given the plaintiff that right?
On the basis of the assumed duty of care in providing a transformer for the consumer at her premises.
Well, that wouldn't give rise to duty of care, would it?
Well,
if it blew up, that would be one thing.
Well, it did fail to provide the requisite voltage. I don't take issue with the suggestion that the judgment is not perhaps absolutely clear in its final analysis, but The point it does make is that the proviso, if I can call it that...
Seems to go further. It says that even your claim for negligence is somehow excluded.
In the absence of the proviso, there is no common law claim for negligence. That's liable to confuse the situation where there is a statutory duty and where there's a common law duty. If one looks at cases relating to the provision of sewers and the obligation to allow anyone to connect to the sewer, and then a complaint when the sewer overflows that there's common law nuisance, there might, in the absence of the statutory provision, appear to be common law nuisance because your property is flooded, but the court has found that there is at common law no duty out there in the context of the statutory provisions for sewers.
If a road traffic statute provides that anyone who drives carelessly shall be liable for such and such a penalty and stops there, it couldn't be arguable that common law remedies were excluded, could it?
I entirely concur, my Lord. It respectfully appears to me, however, that what may have happened was an apprehension that if this proviso wasn't applied generally to these regulations, parties might persist in the belief that the common law remedy was somehow excluded.
Have we got to look at this case in the context of the law as it was? It's a pre-Donoghue and Stevenson
Indeed.
case, and the claim was for economic loss. So he may just be saying, you haven't got a claim in negligence because there isn't a duty of care in these circumstances, so all you're really asking for is a claim for breach of statutory duty, and because of my construction of the regulations, no such claim exists.
That may be so, my lady. It does, however, appear that he distinguishes between Regulations A...
Well, that's what...
Which
yes, he does.
But
He does.
it also seems that he thought he was following Clegg, Parkinson and Irby, which was simply a failure, apparently economic loss caused by a failure to provide gas. I mean, in this case, they were providing too much electricity and it wrecked all the hairdryers.
Yes.
Lord, I don't seek to place too much weight upon the decision itself.
Has it been referred to at all in later jurisprudence?
I'm not aware of it having been referred to.
One wonders where on earth you found it. But
Or indeed why, my lord.
No,
Nevertheless,
it's very interesting.
It's quite interesting.
it was in an endeavour to identify where this proviso came from,
No, it's
because of
very
the assertion that it was somehow an innovation in the 1989 Act. And when one goes back, it is anything but. The proviso has been there for a very long time indeed in this context.
Not all that illuminating as to what the proviso means.
Well, perhaps trying to identify its source can assist. There are some further cases that I would refer to in this context.
Does it suggest that is it suggesting that the word compensation has a particular meaning other than damages?
It allows for the construction of compensation as referring to common law damages in my submission, and it allows for the construction of default as a reference to a breach of a common law duty.
So this case is referred to in Marcasinis and Deakin in the context of what happens where you have a criminal penalty and whether there's a civil remedy, which goes back to the old case of Atkinson, which is referred to by Mr. Justice McNaughton, but it begins by saying, the provision by the Act of a criminal penalty or other remedy for its breach has been seen in numerous cases as having some bearing on the availability of the civil remedy, but it is difficult to draw any clear conclusion either way as to the effect it might have.
Well, my lord,
Do I understand in this old under these there was these A and B regulations, as you said, and that under the ones B regulations, which were for ensuring a proper and sufficient supply, there was only a penalty and nothing about the thing. Whereas the ones relating to safety, the A ones, had the qualification, the proviso in. And 29, section 29, is about is heading up regulations related to supply and safety.
Indeed.
And therefore, for whatever reason, they may have felt it appropriate to say that since in the old days under B, under A you would have had it because it related to safety, then you should put it in
For supply.
for regulations which would relate to supply and safety.
Well, in my respect,
I'm just asking, I don't know.
that is essentially what appears to have happened with regard to the 1937 regulations, because they combine both A and B, and therefore the proviso applies to both.
They combined the two, didn't they?
Indeed.
Yes.
But in A, this doesn't identify what the liability is. So we're back to the same point, really. Where is the basis of the liability?
Absolutely.
And as I understand it, you say, well, it can only be in the common law.
And whereas the old one, these ones talk about the liability, the 37 one talks to the liability brackets, if any.
Absolutely.
And you would say that that is what is reflected in any liability, I
The
presume.
use of the term any liability, not the liability, in section 29, subsection 2.
I suppose one might say that that makes the position clear, although it probably did mean the same, where it says the liability.
I'm not sure I would accept that it would mean the same if it said the liability, my lord, but I just noticed that the way in which section 29, subsection 3 is worded would appear to mirror very closely with the substitute of the word default, what now appears, or did appear in Regulation 37 of the 1937, Regulation 39 of the 1937 regulation.
But section 29.3 can be construed against the background that it's always been a matter of some difficulty and doubt about whether if you provide for one remedy, you exclude others.
Indeed. My lord may be even moving towards an area of understatement, given the two cases that I'm about to refer to. The first is the case of Heard.
Sorry, just before you go on to, forgive me for interrupting, but we do in the statute that we're concerned with now, the 89 Act, there is a reference in section 39.3 to compensation, which is payable to a consumer, isn't it? So that is the statute actually using the word compensation for a particular limited statutory remedy. There's no parallel to that in the earlier statutes, is there, as far as you know?
No, my lord, although there is provision by virtue of paragraph 76 of the schedule to the 1899 Act for penalties that were obtained to be paid to the party who was the victim of the breach.
That's the footnote that we see on page 13 of the report in Stevens, is it? Because I was just wondering whether the penalty was payable to the consumer. It was it?
It was, my lord, and indeed, I believe we can find the schedule to the 1899 Act in volume 5 that my lord has at tab 3. And if we turn to page 31 of tab 3, at 76, the foot of the page, there's a marginal note, recovery and application of penalties, if my lord has that.
So sorry, page what?
It's page 31, my lord, taking the pagination written into the top right-hand corner rather than the pagination of the schedule itself.
This is all the schedules. It's a curious act, but everything is a schedule, practically. One can see from page 1 of the Act.
Indeed, the Act merely says this is the schedule that will be incorporated in all future acts.
Yes, I see.
It's a later attempt in my
Yes.
submission to produce a land clauses.
Yes,
Act.
it is, of course it is, yes.
And at 76, at the foot of the page, all penalties, fees, expenses and other monies recoverable under the special order or under the Board of Trade Regulations, the recovery of which is not otherwise specially provided for, may be recovered summarily in manner provided. Any penalty recovered on prosecution by an officer of the local authority in a case where the local authority are not themselves the undertakers shall, if there is an electric inspector for the time being appointed by the local authority, be paid to that officer and by him to the local authority and shall be applied in aid of the local rate. And then over the page, any penalty recovered on prosecution by any other body or person or any part thereof may, if the court so direct, be paid to that body or person. So if the consumer decided to prosecute, then the penalty may be paid to the consumer.
Yes, and one of the things for which the consumer could prosecute under Regulation 30 on page 19 was a failure to supply.
Precisely.
Yeah.
Precisely. And if we stay there at 77, the undertakers shall be answerable for all accidents, damages and injuries happening through the act or default of the undertakers or of any person in their employment by reason of or in consequence of any of the undertaker's works, and shall save harmless all authorities, bodies and persons by whom any street is repairable, and all other authorities, companies and bodies collectively and individually, and their officers and servants from all damages and costs in respect of those accidents, damages and injuries. And we'll see this provision referred to in a case in a moment. I should say the schedule was repealed by the 1989 Act. But such provisions have been construed as referring to a common law liability and not to an absolute liability.
Well, because it has to be through the act or default of the undertakers.
Indeed so. And we see that.
It's pretty strange to have a private prosecution in Scotland by the consumer, but maybe that's what was envisaged. There's nothing in the application in Scotland that seems to exclude that.
It only deals with arbitration and
Yeah.
various other matters and doesn't actually address that
No,
point.
it doesn't, but there we are.
In 1899, it may have been more common to have a private prosecution with the consent of the Lord Advocate, my Lord.
It wasn't common, but it may have been possible, I suppose. Yeah. It's obviously envisaged, and I presume it must have been envisaged.
If we look at 77, an act in default, a similar provision was considered by the court in the case of Brocklehurst, which is in volume 5 at tab 6. And here, the court was concerned. I should say this is an appeal from the Oldham County Court that concerns Section 55 of the Tramways Act, which was in essentially the same terms as paragraph 77 of the 1899 schedule, which is not perhaps surprising because the development of these schedules was somewhat parasitic. And the argument was that there was somehow absolute liability where the provision was that the promoter should be answerable for all accidents, damages and injuries happening through their act or default, or by reason of their works. And Mr. Justice Denman at page 120, the second paragraph, notes, the section says that the promoters or lessees, as the case may be, shall be answerable. I think the object of this clause, which is one of a number-headed miscellaneous, was to determine who should be liable when there is liability, and not to increase the liability of the company or promoters or lessees beyond what would exist in the absence of such a clause. They shall be answerable for all accident, damages and injuries happening through their act or default, or through the act or default of any person in their employment by reason or in consequence of any of their works or carriages. It appears to me that accident, damages and injuries happening through their act or default must be confined to accidents, damages and injuries which happen through some wrongful act of theirs, either in the nature of an act of commission or an act of omission or default, which is an act of omission. And that is the real distinction which is to be drawn between these two words. By reason or in consequence of any of their works or carriages, that is, if either in laying down the tramways or through any of the works by an act of omission or commission an accident happens, the promoters or lessees shall be answerable, and if in consequence of the legal use of the highway some wrongful act is done or neglect takes place, such as neglect to scotch a wheel, and an accident happens through that, an action shall lie. But there is nothing in this Act to bring about such a result as that a company using their carriages on the tramway, which was authorised by Parliament, and having carriages properly constructed, and as to which there is no act or omission which makes them unsuitable for use, and worked by servants guilty of no negligence, should be answerable for a pure accident, not caused by any wrongful act or default. And Mr. Justice Wills was of the same opinion. That point arose again in the Court of Appeal more recently in the case of Rowe and Sheffield Council, which I believe my Lady Hale.
I was just thinking about it before we got there.
It's at tab 21, my lady.
Yeah.
In volume 4.
Yes?
And a decision of the Court of Appeal of Lord Justice Pill, Lord Justice Sedley and Lady Justice Hale on the point at issue, Lord Justice Pill and Lady Justice Hale agreed. Lord Justice Sedley dissented. But essentially, although there were other statutory provisions that may have given rise to statutory liability, on this point, the Court of Appeal was of the opinion that the conclusion arrived at in Brocklehurst was right, and your lordships will see that Brocklehurst was cited to the court in that case. And if I can take the court to Lord Justice Pill at page 665, paragraph 25, that's letter H. Section 55 provides that promoters or lessees, as the case may be, shall be answerable for all accidents, damages and injuries happening through their act or default, or through the act or default of any person in their employment, by reason or in consequence of any of their works or carriages, and shall save harmless all road and other authorities, companies or bodies. There's then a reference to the 1988 Act and a reference to the Highways Act. And if we then if the Lord allows me a moment, having quoted the section, I've mislaid the passage I was going to refer to. There's a heading, actionability, and a reference to Lord Brian Wilkinson. And then if we go on to paragraph 40 at page 670, the judge considered the relevance of section 55. Mr. Burrell submitted that the section is present to provide an injured road user with a cause of action under the statute, and that the expression act of default includes a breach of the statutory duties. Mr. Maxwell and Mr. Sales submitted that the first part of the section does no more than state the obvious in confirming the existence of common law remedies, and referred to Brocklehurst, and in particular to Mr. Justice Denman, where he said that the expression act of default is appropriate for that purpose. And they submitted that provisions for vicarious liability indicate that the section contemplates common law liability. And in paragraph 41, Lord Justice Pill continues, I consider that the inclusion of section 51 is capable of explanation on the basis advocated by the company and the Secretary of State. And that was counsel, Mr. Maxwell and Mr. Sales. While confirming the existence of common law remedies, however, it does nothing to cast doubt on the creation of such a cause of action by other provisions of the statute itself. And Lady Justice Hale, as she then was, concurred with Lord Justice Hill at paragraph 101, she added some further remarks with reference to other statutory provisions and obligations, but nothing, as I see it or note it, with reference to Section 55 of the Tramways Act.
What do you take from this, then, for present purposes?
Simply that a provision such as Section 55 and indeed paragraph 77 of the 1899 schedule does no more than make provision for common law liability, and is not to be construed as imposing a liability for breach of regulation or statutory obligation.
The conclusion of 41, paragraph 41, is it does nothing to cast doubt on the creation of such a cause of action by other provisions.
Indeed, because there were in that case other
Yes.
very distinct statutory provisions which did create a liability.
So this wasn't to be taken as a pointer that there wouldn't be other sources of liability.
Precisely so. And the relevance of that becomes apparent when we look at an old Court of Appeal decision where they did regard that provision as a pointer. And that is the case of Hurd. And Brimbo's Steel, which is in volume 5 at tab 7. And this is a decision of the Court of Appeal from 1947, in which they are addressing an alleged breach of the Electricity Supply Regulations 1937. And what the Court of Appeal said here was not that the regulations gave rise to a civil liability for breach of statutory duty, but that if you read them in conjunction with paragraph 77 of the schedule to the 1899 Act, then that gave rise to civil liability for a breach of the regulations. And if I go to the rubric, a person injured through a breach by an electricity undertaker of the Electricity Supply Regulations 1937 has a right of action against the undertaker in respect of the breach, independently of any question of negligence. Now, that's not, in fact, a precise or accurate reflection of what the Lordship said, which we'll come to in a moment, but it continues. The factory at which the plaintiff was employed was supplied with electricity from a substation of the electricity undertakers for the district. A switch at that substation controlled the flow of electricity to the employer's factory and was supposed to be so set as automatically to cut off the current or to trip if a defect developed in the line carrying current from the substation to the factory. Current entered the factory by a central switch, which was intended to be so set that it would trip if a defect developed in the electricity system of the factory. Its tripping would thus cut off all current from the factory and prevent further danger. And if that control switch and the switch at the substation were properly set, the former, in the event of a defect in the factory, would trip before the latter. In fact, however, a short circuit having caused an explosion in the factory, the control switch failed to trip, while the switch at the substation tripped. An employee of the undertaker, having a few minutes later re-engaged the switch at the substation, current flowed back into the factory, causing a second explosion, which injured the plaintiff while he was investigating the first. The control switch at the factory belonged to and was under the control of the undertakers. It was held that the employers were in breach of Regulation 1 of the Electricity Regulations 1908, since the first short circuit and explosion in the factory had occurred because the insulator at that point had not been so maintained as to prevent danger, that they were also in breach of that regulation in that the control switch at the factory was not properly maintained or set, that the undertakers were in breach of Regulation 25 of the Electricity Supply Regulations 1937 in respect of their failure to maintain either the control switch at the factory or the switch at the substation in a safe condition or properly set, that the employers and the undertakers were liable to the plaintiff for their respective breaches of regulation, and that while each must be held liable to the plaintiff for the full amount of the damages as between themselves, the damages should be borne as to 1/3 to the employers and as to 2/3 by the undertakers. Lord, I pause to observe, Lord and Lady, this case was not cited before the inner house or the outer house. nor was it cited in the case of Roe and Sheffield Council. If we go to page 696, we have Lord Justice Morrison beginning by saying, "I will ask my brethren to deliver judgment first." And then Lord Justice Somerville, and he deals with the employer first, but if we turn on to page 698, he turns to the liability of the power company, about 1/3 of the way down the page. And he says, "The liability of the power company turns on the Electricity Supply Regulations 1937, and these are the regulations that we looked at a moment ago. By Regulation 24, which is headed Protection of Consumers' Installations Against Excess Energy, there must be an automatic circuit breaker or some other device. Regulation 25 is the important one and provides the undertaker shall be responsible for all electric lines and apparatus placed by them on the premises of a consumer and either belonging to the undertakers or under their control, being installed and maintained in a safe condition and suitable for their respective purposes, and being so fixed and protected as to prevent, so far as is reasonably practicable, leakage to any adjacent metal." On the question, what is the liability, whether solely a liability in negligence, Mr. Howard for the power company referred to certain authorities and to the schedule to the Electric Lighting Clauses Act 1899, which he accepted as applying to the power company. By paragraph 77, headed undertakers to be responsible for all damages, and he then quotes paragraph 77 that we've looked at. And his lordship continues, "There is some authority, not particularly helpful on the facts of this case, on the meaning of the words act of the fault." It's not apparent that Brocklehurst was cited, my lords, but I say that only because it's not mentioned, but it's difficult to discern what cases were cited. If he then says, Regulation 39 provides, if the undertaker...
It is.
Sorry,
sorry.
page 695, towards the foot of the page, it's mentioned.
I apologise, my lords, that is my oversight. It was cited there. I was looking to Midwood and Manchester, but indeed Brocklehurst and Manchester is also cited. I apologise. That may be why he says that there is some authority not particularly helpful on the facts of this case on the meaning of the words act of the fault. And he says, but Regulation 39 provides, if the undertakers make the fault in complying with any of the preceding regulations, they shall, subject to the provisions of Regulation 38 and of any act or order relating to the undertaking, be liable on conviction to a penalty not exceeding £10 for every such default and to a daily penalty not exceeding £10. The recovery of a penalty under these regulations shall not affect the liability of any of the undertakers to make compensation in respect of any damage or injury which may have been caused by reason of the default. And Lord Justice Somerville then continued, it seems to me that in those circumstances, the default, which is a breach of the regulations which may cause damage or injury under Regulation 39, is a default for which the undertakers are answerable under paragraph 77 of the schedule. And I think not merely the fact that the same word is used, but the whole wording of Regulation 39 reinforces that view. So Lord Justice Somerville founds the statutory liability upon the wording of paragraph 77 of the schedule to the 1899 Act, rather than the provisions of the regulations themselves. Now that conclusion, in my submission, is not consistent with the view taken of such wording, either in Brocklehurst or later by the Court of Appeal in the case of Roe and Sheffield Council. That apart, of course, the schedule to the 1899 Act was repealed in 1989. Lord Justice Tucker touches upon the matter at page 700 and says this in the second paragraph, I also agree that the power company are liable in respect of switch number 1 on the ground of failure to comply with regulations 24 and 25 of the Electricity Supply Regulations 1937. I think that on the true construction of those regulations and having regard to Regulation 39 and paragraph 77 of the 1899 schedule, it is reasonably clear that the undertakers are liable in damages for personal injury to an employee of a customer to whom they supplied current for any default on their part under the regulations. For these reasons, I agree that the appeal succeeds. 2 points. Again, Lord Justice Tucker appears to pray and aid the provisions of paragraph 77 of the 1899 schedule. Further, the duty appears to be owed to customers or their employees, although that may be to read his observations too narrowly.
Well, they simply held, didn't they, the default included a breach of the regulations.
A default as provided for by paragraph 77 of the schedule could include a breach of the relevant regulations, my lord. Was the
and Regulation 39, which also referred to default. He said, well, it must be wide enough to include that. Never mind the common law position.
Indeed, sir.
He's not saying that they wouldn't be liable at common law.
No, my lord.
See Lord Justice Somerville at page 699.
But the liability would appear to be founded upon a breach of paragraph 77 of the 1899 schedule. Albeit when essentially identical wording is construed by the Court of Appeal in the case of Roe, albeit without the benefit of being referred to this decision, the Court of Appeal arrived at a contrary view as regards the construction of that wording.
Oh, the perils of legal researches that only look at the particular statutes with which you're concerned.
Indeed, my lady.
Well, what difference
Even with the greatest possible backup from the Treasury Solicitor, which was what was going on in that case.
Unfortunately, I had the very able assistance of my learned junior. And
that was meant to be a compliment.
So what is the position then on these two alternative ways of looking at it then?
on one view, I could respond to my lord by saying, well, the schedule to the 1899 Act has been repealed, so whatever may have been the position, it no longer obtains. But it respectfully appears to me that if one is attempting to make sense of these developments, I would be led to the submission that the decision in Hurd was wrong, and that the decision in Roe should be referred. But what is interesting about Hurd, in my submission, is that the Court of Appeal did not feel able to find that a breach of the 1937 regulations would, of itself, give rise to a civil liability for breach of statutory duty. They felt obliged to pray and aid the provisions of paragraph 77 of the 1899 schedule. So I would take this much from it, my lords, my lady. No court appears to have been satisfied that either the 1937 regulations or the relevant provisions of the Electricity Acts would of themselves give rise to a civil liability for breach of statutory duty absent the schedule to the 1899 Act. But in my submission, what is perhaps most remarkable is that one has to look so hard to find any evidence of any party seeking to maintain a case founded upon a breach of the relevant electricity regulations. And that is over a period of more than 100 years.
Yes?
What one does have are one or two instances in which claims have been made and it has simply been assumed that there is such a liability. And turning to our note of argument, or our case, I should say, at paragraph 64, there are three cases cited, two in Scotland and one in England, one doesn't learn a great deal from going to the reports themselves, my lords, my lady, in which it was averred that there was a breach of the relevant regulations and no issue was taken with that.
I mean, there's no plea to the relevancy.
There was no suggestion
No argument
that the
about
regulations were not relevantly pled. Precisely so, my lord.
And the same applies to man, does it?
It's a very brief report, my lord, and I'm quite content to take your lordships and my lady to them, but...
Can you just give the
Give
reference?
us, yes.
The references are given, I believe...
Have we got tab references?
Volume 3, tab 3, 13, sorry, volume 3 at tab 2 and volume 3 at tab 12 are the three references.
So it's 313, 3, 2 and 312.
It's volume 3, tab 13, tab 2 and tab 12 and the order in which they appear. I'm perfectly content to go to the reports, but they really don't elucidate the matter at all.
The issues were quite different, were they?
Well, one can simply notice that a breach of the regulations was pled and no issue was taken with the relevancy of that part of the case.
Actually, I think it's 11. It's tab 11, the man case.
I apologise if my numbering...
Rule tab 12 is Marchridge.
Yeah, the lady is quite right.
Were these all cases of personal injury as a matter of interest?
I was just looking at McLean, lady. One is certainly a hotel case.
That's what I tell you.
I'm advised that McLean was a case involving a cable.
Yeah, certainly can see that.
Very similar.
Fire, isn't it?
Yes, it was. Probably done.
Alexandra Hotel was property damage.
Looks to me as though it's property damage as well in McLean, I would have thought. We can probably get it in.
And indeed, Alexandra Hotel was a decision at procedural.
Yes.
As I read the cases, there was no issue raised about the relevancy of a case founded upon breach of the regulations.
Yes.
My lords, my lady, can I turn back from that case law to the regulations themselves, which are at volume 13. I'm sorry, tab 13 of volume 2. And it may be noted that these regulations are, to a degree, really quite technical.
A lot about earthing and things like that.
Well, if we look at part 2, it's to do with the connection with Earth.
Yeah.
If we look at part 3, it's to do with lines below ground. If we look at part 4, it's to do with lines above ground. If you look at part 5, it's suppliers' works, and of course there's a provision on sufficiency of suppliers' works that's relied upon here. And there's a provision at 24 with regard to inspection of works,
Which are the regulations that are relied upon? 17?
17, 24 and 25, my lord. And then part 6, supply to consumers' installations. Which is also relied upon. Regulation 26 may be noted, it's to do with interconnected supplies, that is where there's more than one source of supply. And its ambit is not limited to suppliers and to consumers. Any person who knowingly provides energy to a consumer's installation or allows any electric lines in his ownership or under his control to be used for that purpose falls under the provisions of Regulation 26.
I'm not sure that I really grasped the inwardness of that provision.
The concern would appear to be that if you have more than one source of supply, the risk of overload or failure, if they are not properly controlled as between each other, has to be addressed. And Regulation 32 refers to the obligations of electricity boards. That then became the relevant licence holders after the 1989 Act. And then Regulation 38 is works in breach of regulations. And in my submission, it is noteworthy that the regulation concerned with works in breach of regulations has its own dispute resolution process built into it, involving a notice procedure. Regulation 38 provides that paragraphs 2 to 10 shall apply in any case where the Secretary of State is satisfied that any supplier's works or any part thereof which are constructed, placed, erected, maintained or used otherwise than in accordance with these regulations, or B, any part of a consumer's installation which is not enclosed in a building, or C, those works, that installation or the part thereof which are or is in breach of any relevant exemption or other relevant provision made under these regulations in force at the time when the notice referred to in paragraph 2 is given, are or is liable to 1, become a source of danger to others, or 2, interfere with a supply to others. And of course the consumer's installation could end up interfering with supply to others. The Secretary of State may serve notice in writing on the supplier or consumer, specifying the matter of which he is satisfied, and require that those works, that installation, or the parts specified in the notice shall not be used, or shall be made dead, or shall be removed.
And how does the Secretary of State find out about all these things? Is this through inspectors or what is it?
If we go back to the 1989 Act, my lord, we have the provision for electricity inspectors under Section 30.
That's it.
We also have provision for complaint to what were then the consumer committees, and the reference to the Director General, that would now be Ofgem, and thereafter further references. So there are a series of mechanisms, my Lord, within the Act for bringing these matters to the attention of the Secretary of State. And he can then serve a notice where such a notice is required that any works shall not be used or should be made dead. That
Well,
notice.
the previous provision provides that you've got to comply with the notice.
Absolutely,
Yeah.
absolutely. And then essentially from 38.5 to 38.10, there's a dispute resolution procedure where a notice is given to the Secretary of State pursuant to paragraph 4. The Secretary of State shall refer the dispute to an independent person agreed between the Secretary of State and the person giving the notice, or in default of agreement to a person nominated by the President for the time being of the IEE. The person to whom a dispute is referred shall, on reaching a determination of the dispute, make a direction as to whether the person giving the notice under paragraph 4 shall bear the costs of the reference, or whether those costs should be borne by the Secretary of State. The person to whom a dispute is referred may decide to uphold the notice or to recommend that the notice be withdrawn or modified. The person to whom a dispute is referred may, and if so requested by any party to the dispute, shall give the parties an opportunity of appearing before and being heard by him, and make an inspection of the supplier's works or consumer's installation, the subject of the dispute. Where it appears to the person to whom the dispute is referred that any person not being a party to the dispute has an interest in the outcome of that dispute, he may at his discretion treat that person as if he were a party to the dispute. And then there's a provision for notification. So there is a clear mechanism within the regulations themselves for addressing works in breach of the regulations, for the giving of notices, and indeed for any issue that arises with regard to such notices.
I mean, as I understand it, the facts, insofar as I understand it, it relates to fuse on one of the premises. Is that right?
My understanding, my Lord, is that there are two premises, and in one we have a consumer of electricity, and there was placed within a fuse what was referred to as a shim, and that is, we accept for present purposes, the source of the fire. There is an issue of fact as to who placed the shim there, but put that to one side for the moment. The consumer's premises suffered damage by fire, and the landlord has a consequent claim, but neighbouring premises were then damaged, and they have...
But it's in the sort of fuse box.
It's in the fuse box.
In the premises.
In the premises. In the consumer's premises.
It's not terribly easy to see how these mechanisms would actually root out that particular problem, is it?
That problem as such, I accept, would not be directly addressed. But if, for example, there was an issue about the condition of the fuse box raised by the supplier, he could refer the consumer and vice versa. And a notice could then be served requiring either the supplier or the consumer to deal with the matter. And if there was an issue as to who was responsible, that could then be referred to determination under Regulation 38.
But I mean, I'm not aware of inspectors from the Secretary of State ever having come to look at my fuse box, or the fuse box on my premises, I don't think. Do they do that?
Well,
maybe they do, I just simply don't know.
I must assume that as they've been given the power to do so, they exercise that power, but I can't speak in detail to it. But if my Lord allows me a moment. I understand the Lord's meter is probably inspected once a year.
They have difficulty enough to get the meter reading out of me.
That's what's supposed to happen. What happens if you don't comply with one of these notices?
Then, in terms of Regulation 39, you're guilty of an offence.
And that's all, though, is it?
Well, not according to the respondents.
Well, maybe we could get mandamus. Can they get...
Well, the respondents take a very narrow view of the proviso. They say that it doesn't give a consumer any right to seek any form of civil relief over a breach of the regulations. It only gives them a right to claim damages when they've suffered loss. So if you're anticipating loss, there's nothing you can do about it. But if you wait till you've suffered it, then you can complain about it under the regulations. That is what I understand the respondent's position to be.
But you say that if I thought that there was a dangerous thing in my fuse box, whatever it was, then this would be then section 13.8 would provide a mechanism.
And the mechanisms within the 1989 Act for raising the matter with what was then the relevant Consumers Committee and asking for a referral if necessary and an appropriate notice. And then there might be a dispute with the supplier saying, well, it's not my responsibility.
The trouble is, if it blows up in the meantime, you're stuck. Unless you can prove negligence. In which case you're all right.
That applies in many walks of life in my submission.
Follow that.
Is it common ground that the fuse box is supplier's works, in the meaning of the regulation?
I understand.
Or for the purpose of this debate, it must be. But
Milady, I understand that fuse box is part of the distribution, and it's what's taken from that into the consumer's premises that is part of the consumer's installation.
we may be mistaking the sort of fuse boxes over which we have control with the sort of fuse boxes.
That's what I was wondering.
It's prompted by my Lord's questions.
I wonder if my lady would allow me a moment.
That's what I was wondering. Yes, I just wondered about that. I just wondered.
Beyond the meter, there will be the fuse box with the circuit breakers, and that is the consumer's installation,
Consumers, yes.
not the distributor's installation.
Yeah. So this fuse here is what?
It's before the meter.
Yes, exactly.
No, it is past the meter,
Past the meter.
but the statutory obligation that is relied upon is the obligation to inspect the consumer's installation.
Right.
To inspect the consumer's installation.
Precisely.
Oh,
That's where the inspection, is that where the that's the... That's
but you're also
regulation.
relying on Regulation 17, which is
Indeed.
supplier's works.
But
That's why I asked.
That was one of the reasons I asked earlier on about whether or not the relevancy of these environments was conceded.
At any rate, you concede, as I understand it, that if you're wrong, then there's a breach of these regulations. Whether that's a concession rightly made is not for us to consider.
25 at any rate.
It is Regulation 25 that is also cited, which is supplier's works on consumer's premises.
Well, that would be appropriate. Time to break, and we'll resume at 2 o'clock.